I'm going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Leitner.
Here.
Representatives Begol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter. Hope.
Here.
Breen.
Present.
Scott.
Present.
Madam Chair, you have 10 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Begol moves to adopt the minutes from December 10th. That's not right. Yeah. Yeah, it is. Sorry. Yep, December 10th. Hearing no objection, the minutes are adopted. Rep. Wozniak moves to excuse absent members. Hearing no objection, absent members are excused. Okay. We have a loaded agenda today. So I'm just going to give a couple of housekeeping instructions. For those wishing to make public comment today, please fill out a card. We already have numerous cards up here. We did get email cards of support and opposition as well, which I can address at the end. There are numerous. The clerk has already entered them in, so I'm not going to read every single one of them because there's this many. So it'll take up all your time. And then some. But if anybody else that is here would like to make public comment, please fill out a card and turn it into the clerk so if we have time, we can get to you. If any members of the public do come up to speak, please remember that public comment is an opportunity to address us, the legislators. Therefore, please address the chair. In addition, public comment is not a question and answer session. It's simply a chance for people to speak to this legislative body. Legislators are not required to answer any questions that may be posed by the speaker during this public comment. Finally, there's a large number of you that wish to speak on these bills today. We do have limited time as there's another committee hearing at noon in this room. So we're going to try to wrap up by 11:45, 11:50 today. If we're unable to provide everyone with the opportunity to speak here in person, please remember that public comments can be submitted in writing and submitted to the committee clerk, and they will be included in the record. All right. With that, we are going to move on to a couple of quick votes. First up, we are going to have Rep. Begol move House Bill 5314 with recommendation. Madam Clerk, please call the vote.
Chair Leitner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter. Hope.
No.
Breen.
Absolutely no.
Scott.
No.
Madam Chair, you have 7 yeas, 3 nays, 0 pass. House Bill 5314 is reported with recommendation.
Thank you, Madam Clerk. Next up, we will have House Bill 5315. Rep. Scott offers an amendment to House Bill 5315.
Yes. I'm sorry. Go ahead.
Madam Clerk, will you please call the vote on the amendment?
Excuse me, Chair. I would like to speak on this amendment. Thank you.
Okay. I guess I'll allow it.
I
It's pretty
appreciate
simple.
that. Thank you. So what I'm requesting is that you, for 5315, that it be tie-barred to 4576. And the reason why is because the $645 million that was ripped from the communities across the state by the majority party because of the fact that you promised the money in the first place.
Okay, please
So
stick to the amendment. The amendment is very simple. It says it's a tie bar. It has no other information in it. We are going to proceed to voting. Thank you.
Thank you.
Madam Clerk, please call the vote on amendment to House Bill 5315, offered by Rep. Scott.
Chair Leitner.
No.
Representatives Begol.
No.
Wozniak.
No.
Harris.
Absolutely not.
DeBoyer.
No.
Johnson.
No.
Schutte.
No.
Carter.
Yes.
Hope.
Yes.
Breen.
Yes.
Scott.
Absolutely yes.
Madam Chair, you have 4 yeas, 7 nays, 0 pass. The motion does not prevail.
Thank you, Madam Clerk. All right, so we will now proceed to Rep. Wozniak will move to report House Bill 5315 with recommendation. Madam Clerk, please call the vote.
Chair Lightner.
Yes.
Representative Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson. Yes. Shooty.
Yes.
Carter.
No.
Hope. No. Green.
No.
Scott.
No.
Madam Chair, you have 7 yeas, 4 nays, 0 pass. House Bill 5315 is reported with recommendation.
Thank you, Madam Clerk. Next up, we have House Bill 5316. I do have a card of support, not wishing to speak. Dave Worthams of Michigan Manufacturers Association. With that, we are going to have Rep. DeBoyer report House Bill 5316 with recommendation. Madam Clerk, please call the vote.
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
No.
Hope.
No.
Green.
No.
Scott.
No.
Madam Chair, you have 7 yeas, 4 nays, 0 pass. The motion prevails.
Thank you, Madam Clerk. All right, next up, we are going to hear testimony from Representative DeSana in regards to House Bill 4138, 4139, and 4140. Rep. DeSana, if you would like to come up, you have the floor, sir.
Thank you, Chair Leitner and members of the committee for holding testimony on these bills, House Bills 4138, 4139, and 4140. I'm here today with groups representing the gun owners from all over the state of Michigan. We are here today speaking about red flag legislation and presenting our case, something we were not able to do when this law was passed in the spring of 2023. America is built on the foundation of freedom and inalienable God-given rights. The right to self-defense exists in natural law. The founders of our country and our state knew that this right had to be paramount. I have taken an oath to defend this right in both the U.S. Constitution and the Michigan Constitution. Another constitutionally protected right is the right to due process. And I cannot think of any more important right than the right to your day in court, and the right to face your accuser, and the right to tell your story, which has been denied our gun owners in the state of Michigan. I won't go into every detail, and I want to be brief as I can so that I can leave time for people to speak, because I know there's a lot of people who want to speak to this issue. Ensconced in the 14th Amendment, Section 1 says, "No person shall be deprived of life, liberty, or property without due process of law." Article 1, Section 17 of the Michigan Constitution essentially states the same. With gun ownership comes great responsibility. We as gun owners understand this and know this. We believe that much of our problems in society today are due to mental illness. We had a 72-hour commitment law and have a 72-hour commitment law on the books. And I'm here to say that there's a better way to handle this than taking guns away from law-abiding citizens. MCL 330, the Mental Health Code, our 72-hour commitment exists within that code, and it describes mental illness as such. Mental illness means a substantial disorder of thought or mood that significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. An individual who has mental illness and who, as a result of that mental illness, can reasonably be expected within the near future to intentionally or unintentionally seriously physically injure himself, herself, or another individual, or who has engaged in an act or acts and made significant threats that are substantially supportive of the expectation. We already have laws, felonies, that cover when somebody makes a threat outside the mental health code. MCL 750.540, threats through communication. MCL 750.543, terroristic threats, serious felony. MCL 750.235B, school threats, a 10-year felony. I'd like to relate this story to you. We've had a lot of news lately. The news cycle seeing acts of violence with things other than guns, lots of violence with knives. But I'd like to relate to you this story that happened in Dearborn in August of this year. On Thursday, August 21st of this year, Hyder Al-Fadawi of Dearborn, Michigan, was badly beaten. He filed a police report on Friday, the 22nd, identifying the suspect. On the morning of Saturday, the 23rd, he returned to the Dearborn Police Department, asking the police if they could help find this person who was trying to kill him. The officer on duty said he would have to come back and talk to the detective on Monday. Hyder asked, "What if he tries to kill me today or tomorrow?" He said, "Well, you'll just have to come back on Monday and talk to the detective." On the evening, Saturday night, as Hyder was crossing Michigan Avenue, and the video, you can see it, you can Google it, it's out there, it's brutal. He was run down by Murtada Jabbar al-Jaziri. He crossed over into the oncoming lanes and hit Hyder with his car. Hyder just came out of a concussion just recently. He was in a concussion for 2 months, multiple broken bones. So my point is, when somebody really wants to kill somebody, they can use multiple instruments. You can't, we take guns away from people thinking when somebody's made a threat, they can use knives, cars. I could go on and on as to what somebody would do when they really want to kill somebody. Why are we targeting the law-abiding gun owners of Michigan by taking their guns away simply because of a threat? And I'm going to let my experts in the field talk more about how the law has worked. Many of you know of some examples in our state, 2 youths in Northville, a 6-year-old and a 10-year-old in Northville whose family had all their guns taken away because something was said at school that just didn't make sense, whether it was violent or just somebody thought that person had access to guns. And the other thing I think that's happened too, with safe storage, we're now using safe storage as a way to catch somebody and trip them up on red flag. So in all these instances with the youths, their house was visited to find a gun, to see if a gun was out in the open. I don't believe that having a loaded gun in your house is against the law. I don't believe that. I believe that our right to bear arms includes having a gun in your house, and the government does not have the right to tell you how your gun is stored. That's your right as a gun owner, as an American citizen. In the Upper Peninsula, in Alger County, a student made some threats at school, and the family got a visit. The family lost all their guns. We know from reading these stories that in the vast majority of these cases, the families get their guns back because they find out that there's no threat. The child is no threat. The family is no threat. I would be here today to tell you that law-abiding citizens are not a threat, and the fact that they're armed, they are not a threat to society. We need to focus on the criminals. My dad was a mayor of Wyandotte for 30 years. All the police officers in town could tell you they go to the same houses. They call them their clients. They're the same people making the same violent threats. They're in the same trouble over and over and over. It is just very rare to have a law-abiding citizen out of the blue commit violence in our society. We know where our criminals are. We need to enforce our existing laws. We do not need this type of legislation, and I am here today to say we should repeal it. Thank you very much.
Rep. DeBoyer.
Thank you, Representative DeSana, for bringing this forward. And I would say I think it bears repeating one of the items that you touched on early, which was that the issue that we are facing as a society is a mental health crisis. In what we're seeing with these current laws that are in place is that we're treating a symptom, and we believe by trying to eradicate the symptom, which is the use of a gun in a violent act, by taking the gun from the individual, somehow we've solved the individual's problem. We haven't. We've actually exacerbated it. Because instead of that individual getting treatment, proper diagnosis, care, they're just turned right back into society, and we feel better about ourselves because we've taken their gun away. It makes no sense. It is the same failed policies that have been implemented time and time again that don't solve the problem. So I really wanted to just say to you, I appreciate you pointing that significant issue out. And if we're going to move forward and we're going to solve the violence issue, it's going to be through addressing mental health. And by the way, also addressing things like family, parenting, and responsibility. So thank you very much.
Thank you, Rep. DeBoyer. And as it relates to mental illness, if I could just say, the 72-hour hold could be strengthened. I believe it could be strengthened. There's some mental treatment issues that can maybe cause some people to fall through. I really do believe that when a family has a member in a mental health crisis, they really are reaching out to our courts, to our system to say, you've got to hold them. They're going to either kill themselves or kill somebody else. And I believe the 72-hour hold is part of the system that can work if we cooperate with it and our judicial system cooperates with it, and that person will have their day in court, they'll have an attorney, and they'll have due process. There's a better way to do this. Due process is the way to do it.
Thank you. Minority Vice Chair Carter.
Thank you, Madam Chair. So when I look at this, being a retired officer for 25 years, when I started domestic violence, you tell somebody to leave the house. Well, after a few lawsuits, somebody has to go to jail for 24 hours. So there's things that have been done to be preventative. You get your due process. But earlier this year, the State Police and the Sheriff's Association, they presented information before this committee that the ERPA laws had been an effective tool in reducing gun violence. What are your thoughts about this, and have you spoken to the Sheriff's Association or the State Police about your...
I've spoken to my sheriff, my county sheriff in my district.
Who's your county sheriff?
Troy Goodenough.
Okay.
And he happens to be in favor of red flag legislation, to be honest. I think that, and one of the worst instances of violence in my district was a police officer killed answering a domestic violence call. And I feel for the police in dealing with society today, and certainly echo the sentiments of you being a police officer and having to deal with domestic violence situations, and know when you come into those are some of the most dangerous environments and incidences. And I believe that a lot of our cases where we have gun violence are domestic violence instances, and it's a mental health crisis. It's a lot of times it is a argument in the house, and somebody calls the police, and somebody the police officer is suddenly turned as the enemy.
Thank you, Representative Breen.
Thank you, Madam Chair, and welcome, Rep. DeSana. You were talking initially about some fundamental rights, and I would note that, God did not write the Second Amendment. Man did. And you've discussed due process. We have substantive and procedural due process, and that is built into the laws to include an appeal process and a swift hearing if somebody wishes to contest this. I have reviewed multiple cases that have been filed under these laws, and I note that what we are seeing here in Michigan is exactly what we are seeing in other states, and that a vast majority of people who have their firearms confiscated do not attempt to get them back, as most of them are suicidal, and they no longer have that temptation. So, given that, I vehemently contest your assertion that due process is not being followed. So I am wondering, though, have you spoken with any judges that have seen a violation of due process? Because it's to my understanding that after we've received the support from the judges, and also we received support from the sheriffs, the chiefs of police, the Fraternal Order of Police, and I know we all love to back the blue, what judges have pointed to any information that there are violations of due process? Because, again, we are following all the laws in the state, including the decision under Rahimi, in which they found, the Supreme Court found, that somebody who is a credible threat to the safety of another may be temporarily disarmed. Because, again, ERPOs are temporary measures.
I would just argue respectfully that whenever somebody doesn't have their attorney present and doesn't have a day in court and loses their firearms.
I have to absolutely oppose what you're saying there. They do have their day in court. There is an appeals process.
After they've lost their firearms.
Temporarily. They have a hearing within 2 weeks. Has anybody lost their firearms for more than 2 weeks?
And you know also that in reference to people who seek their guns back, I believe it's nationwide, the statistics are over 86% of the guns are returned.
After they have been confiscated for a temporary period of time, which is, a fair amount when somebody is in a mental crisis.
86% of the time, this is a tremendous waste of our police resources to go and collect these guns from people rather than focusing on the violent individuals.
But yet none of the law enforcement organizations are agreeing with you.
Well, I'm not looking for people to agree with me. I think that I know where I stand, and I believe that our God-given rights were written in the Constitution. It's based in natural law. The right to self-defense, the right to bear arms is written in natural law.
And in addition to none of the law enforcement organizations that are supporting this repeal, have you spoken with any judges?
Yes, I have. I've spoken with my Monroe County judges.
Okay, and do they support
Brown,
repeal?
Judge Michael Brown is a very good friend of mine, and he believes that the 72-hour hold, there are some.
I'm not asking about the 72-hour hold. I'm asking about repeal, which is what your bills are aimed to do.
Correct. The reason that I'm here to say that the right to due process being taken away from somebody,
Which is built into these laws.
Madam Representative, will you please let Representative DeSana finish his answer before you interrupt him again and again and again, please?
I would
Please.
like the answer to the question if the judges support repeal.
I'm not going to answer that question. The 72-hour hold gives a person due process and accomplishes exactly the purpose involved, which is stopping the violent individual from injuring himself or another person. You can hold the person for 72 hours. They see a judge. And if it's a false accusation or just maybe an exaggeration, they're able to make their case to the judge and say, listen, somebody is making a allegation against me. It's not true. I'm peaceful. I'm not going to do anything. This process that we have right now, automatically you are assumed guilty until after your guns are seized, you're assumed guilty. With a 72-hour hold, you immediately have the right to an attorney.
There's no presumption of guilt with these, sir.
Well,
It is a temporary hold.
Okay. Representative Schuette.
Thank you, Madam Chair. I want to continue on this topic of due process and how our legal system is working with the extreme risk protection order. So, am I correct that a extreme risk protection order can be granted without any notice to the respondent?
correct.
Okay. And that order can be granted without notice, and then the restrained person has the burden to have it lifted.
Correct.
Okay.
The burden of proof is upon.
The burden of proof. So that takes our traditional function of our judicial process and flips it to put the burden on the respondent.
And I
Thank
believe also that it can be pulled from anywhere in the state of Michigan.
Yeah. Thank you.
County.
Rep Scott.
Thank you, Chair. Thank you for your testimony, Representative. Are you concerned that pushing these bills would be a proverbial slap in the face to all the families who've lost loved ones, and particularly the Oxford shooting and the University of Michigan?
My
Michigan
heart
State
goes
shooting?
out to anybody who is killed in any type of violence. Why are we singling out people killed with guns? My heart goes out to this gentleman almost killed by a car or a knife. We've had a knifing just in our news in the past week. We don't take knives away. We don't take cars away. I mean, if we did take somebody's car away, I think they'd have the right to go to court before they had their car taken away.
Okay, thank you.
Representative Hope.
Thank you. You mentioned God-given rights and the Bill of Rights, and I just wonder if you're aware that other constitutional rights have limitations, and do you believe that the Second Amendment is absolute?
I do. I believe that the right to self-defense, to defend your life against a threat, is absolute. I believe that's in the Catechism. It's in natural law. I believe it was in the Magna Carta. I think that our right to defend ourselves is absolute. And I believe our founding fathers ensconced that right because they had just had a tyrannical government try to take their lives.
All right. Representative, you can continue to sit there or at one of the other microphones. I'm going to have,
To the right.
okay. First up, I'm going to have Nick Bougie wishing to speak, supporting the bills from the NRA. If you would please approach the podium. Keep your comments to under 3 minutes, please. And you have the floor. Thank you.
All right, thank you, Madam Chair, members of the committee, for allowing me to testify today. I will try to keep this brief. As Rep. DeBoyer and Rep. DeSana said, there could be multiple ways to look at finding a solution to this issue, but the answer to the question should never be to strip citizens of their rights and making them less free. The NRA does not and will not support any policy proposal that implements sweeping gun bans that arbitrarily strip law-abiding citizens of their Second Amendment rights without due process. Due process is a cornerstone of our democracy, so much so that it's mentioned in multiple amendments. The Fifth Amendment spells out various protections against arbitrary action by the federal government, including that no person shall be deprived of life, liberty, or property without due process of law. Likewise, the 14th Amendment, enacted after the Civil War to protect Americans from abusive state practices, declares, "Nor shall the state deprive any person of life, liberty, or property without due process of law." These so-called red flag laws that this package would repeal are a flagrant attack on the due process. They grant the government the authority to eliminate a person's Second Amendment rights and seize their firearms ex parte. This means that these confiscation orders are issued without a hearing or an opportunity for the target of the order to be heard and present evidence. The target of such an order need not be accused of having committed any crime. Moreover, the current law permits the government to seize firearms based on weak standards of evidence and accusations. Often the first time someone might be aware an order was enacted is when a police officer shows up and confiscates the individual's firearms. Everyone should have the right to plead their case in court before being stripped of a constitutional right. Furthermore, the categories of individuals that are able to file for these petitions is also incredibly broad. For example, an individual who has or has had a dating relationship with a respondent, or an individual who resides or has resided in the same household with a respondent. These are very broad and ill-defined categories that lead to abuse in the law. Any questions?
Rep. Harris.
Thank you, Madam Chair. I appreciate you, Rep. DeSana, and I appreciate the NRA being involved. And I know many people in this room were here during the original hearings, and I just want to point back to something. Prosecutor Karen McDonald actually made a statement during the initial hearing on this, and it had to do with the burden of proof should be placed upon the petitioner, not upon the respondent. I think that's pretty powerful coming from a prosecutor that has some of the feelings that Karen McDonald does. And I happen to agree with her. I think the burden of proof should be on the petitioner, not on the person that has to go defend themselves. And Rep. DeSana, and I meant to say it earlier, I had this exact conversation. I appreciate that the original bill sponsor was open to having the conversation, but I had this conversation about the alternatives and the issue with due process with the ERPO bills versus going the alternative route. Unfortunately, I think it fell on deaf ears because we saw where the legislation went. But I think due process is a huge, huge piece of this, and I think we need to get back to some common sense on this.
We're innocent till proven guilty. That's what we all grew up believing, right?
Rep. Breen.
Thank you, Madam Chair, and thank you for bringing up some of these constitutional rights. And I guess my question is, it's short and simple. you think it's more appropriate to deprive somebody of their freedoms with an involuntarily hold, jeopardizing their job, their reputation, than it is to temporarily relieve them of their firearms for maybe at most 2 weeks when they have a hearing?
I mean, I believe that everybody should have their day in court, and they should be able to, the petitioner should be able to present evidence, the accused should be able to present evidence, and the judge should be able to make that decision. Whatever that decision is, it should happen in front of a court, fairly.
And you understand, though, that is what exactly happens with the current ERPO process?
No, not if it's an ex parte order. A judge can order your firearms rights restricted without you ever being present, without you ever being aware that something was filed, without you being able to plead your case. So I think the issue is yes, can you have a hearing afterwards, after you've been stripped of your rights? Yes, but that isn't innocent that isn't, the assumption isn't you're innocent until proven guilty. The assumption is you're guilty and now you have to prove you're innocent.
Well, one final question then. Somebody calls a Social Security agency and says that they are going to shoot up their asses after he finishes drinking his beer. And you'll be seeing my name on the news today. I need my money. I'm coming to the Social Security office, and they're going to find out. Do you think it's more appropriate then to put that person on a 72-hour hold and let them immediately have access to their firearms after?
I mean, I believe I'd call law enforcement and have them sort it out. Maybe they do need mental health services, but going to court and going through this process is going to take longer than calling the police and having them, figure out the situation.
Could I speak to that for a second?
Yeah.
I did mention in my, and I'd just like to reiterate, that person would be guilty of a felony under the regular law, 750.543, terroristic threats. You don't need a 72-hour hold. You go and arrest that person for making threats. It's in the law. Let's just enforce the law we have.
Thank you. Okay, we are going to move on to the next person who is scheduled to speak. Oh, wait. No, that's mine. Sorry. Brendan Boudreau from Great Lakes Gun Rights, wishing to speak and supports the bill.
Thank you, Madam Chair, members of the committee, for the opportunity to testify in favor of these bills to repeal this outrageous abomination of a law that passed with biased and unequal, nonsensical committee hearings just 2 years ago. With me, you'll see a stack of boxes there. Those are the petitions of over 10,000 Michiganders who support the repeal of this law. This bill package is co-sponsored by 24 state representatives along with Representative DeSana. This goes to show you how much outrage this law has caused in the state of Michigan. Contrary to the claim of its proponents, this law has not made us safer, but what it has done is allowed for countless legally owned firearms to be confiscated from otherwise law-abiding citizens without due process. The Detroit News reported earlier this year that the gun confiscation law is being used to red flag minor children, leading to the firearms of their parents being confiscated. The parents are not even subjected to subject to the order, yet their guns are being confiscated. You're claiming that there's due process, but those parents are being completely denied their due process. What's worse is that this is not even an abuse of the law. This isn't even a mistake in drafting, now that we'd be able to point it out anyways back in 2023, but rather it was pushed by the proponents as a feature of their law. What other constitutionally protected right do we allow for government agents to seize private property from a person who has not even been accused of a crime? This is outrageous. Bridge, Michigan also reported earlier this year that of the 287 gun confiscation orders issued, only 11% of them led to the individual being charged with a crime. So while proponents will champion this as some kind of success story, please keep in mind that means that they got it wrong at least 89% of the time. Red flag laws are a failure. They're an abomination to the rights we have as citizens of this constitutional republic, and the Michigan legislature would do well to repeal it completely. I urge the committee to vote yes on these bills and send it to the House floor for immediate consideration.
Okay, thank you.
Thank you.
Next up for our next scheduled guest, Tom Lambert, who wishes to speak, supporting the bills from Michigan Open Carry. Tom, if you Come on up. You have the floor, sir.
Members of the committee, thank you for your time. Thank you for being willing to hear what the committee was afraid to hear 2 years ago. I want to be very clear. This we're talking about today is not a question of whether we handle certain individuals. Today's question is how do we handle those individuals? As you've already heard, there are existing tools in the law that have been there for a long time and work better. If somebody calls the Social Security Administration and makes a true threat, why on earth would we leave this person in the community? Oh, hey, you signed a paper saying you gave us all their guns. I guess we can trust you now. Wink, wink, nudge, nudge. Everything's fine now. Why on earth would we leave that person in the community? This gives a false sense of hope because it is absolutely a horrible fit to the it is a horrible fit to the problem it has been put forward to supposedly solve. If you are indeed a threat, you need to be dealt with right now, not later. And if you are not a threat, why do we have this incredibly low standard that strips not just your rights, but the rights of those around you? Let's say hypothetically that my wife says something on social media and the officers in our area petition for an order against her, and they come and take my firearms. Where's my opportunity for a hearing? Forget before they come and take my firearms. I'm not the subject of an order. Nothing in the law whatsoever says that I have a right to a hearing. My wife might at some point. I never do, before or afterwards. That was there in the beginning. It has worked that way throughout this entire time. And don't get me wrong, do not dismiss these examples that you are going to hear about today as one-offs or whoops, something happened wrong. This law is working exactly as it was intended to work. And to be very clear, those are not my words. Bridge, Michigan, February of this year. It looks to me like it's working exactly the way we intended. State Representative Kelly Breen. Senator McMorrow sponsored the legislation, February of this year. Clear evidence that the law is working exactly as intended. And this is after these examples already came to light. Examples of 6-year-olds being subject to these orders, and then they go take everything from the parents. This isn't just a Second Amendment issue. I'm not here today just on behalf of gun owners. I'm here today on behalf of every citizen in the state because you don't have to own a gun to have one of these orders against you. The legislation specifically says so. Everyone, every breathing person in this state is subject to having their rights violated by this order. Everyone, not just their Second Amendment rights, their First Amendment rights. Post something on social media that isn't a true threat can be used against you. Your Fourth Amendment rights. The standard in here, the standard that was written by the former committee chair in this very committee, what I call the might-maybe standard. Let's do that weird thing and actually go to the actual language of the law. MCL 691.1807, sub 1. The court determines by the preponderance of the evidence that the respondent can reasonably be expected. I'm an attorney. I handle evidentiary standards. Evidentiary standards are meant to show that something is true or not. Is it true by preponderance of the evidence? Is it true beyond a reasonable doubt? You will do something by the standard. You did something by the standard. That's not what's going on here. It's preponderance of the evidence, okay, but that the respondent can reasonably be expected? So this is like reasonable suspicion, which is already the lowest evidentiary standard in the state, but it's not even reasonable suspicion, it's preponderance of the evidence that you might have reasonable suspicion. This is nonsense. Nonsense, and that's why we see so many of these issued on an ex parte basis. This is not communities protecting their loved ones as it was sold to be. That was an absolute lie. The vast majority of petitioners for these are not people petitioning for them against people they know. It is law enforcement petitioning against people in their community without personal knowledge. I want to be very clear about that. Oftentimes an officer will respond, another one in the department will fill out the petition for an IRPRO. How do they get this How do they even meet the standard they have to meet without personal knowledge? And according to data released by SCAO, over 90% of these, over 90%, are petitioned and granted on an ex parte basis, if not an immediate ex parte basis. We talked about ex parte here, but there's another thing in the law that's kind of this super ex parte. We can skip the whole paperwork process and do paperwork and due process. If an officer just calls the court, says a number of things, and that's it. You can get this immediate ex parte order. And then when you go to court, you finally get your day in court, you now have to show by preponderance of the evidence that you are no longer a threat. Listen to that language. Listen. You are no longer a threat. It's not, hey, did we get this right in the first place? It's, you're presumed to have been a threat. We're not going to talk about whether you were a threat or whether we got this right in the first place. This was, you now have to show us, that you're no longer a threat. Fourth Amendment issues, because the standard to get one of these is less than probable cause. So you have to have probable cause to get into my house on a search warrant, but under these, because it's that maybe standards, that's maybe not even reasonable suspicion, you can get into my house with less than probable cause now to search my firearms. You have Fourth Amendment issues. 2015, the United States Supreme Court in Henderson held that even felons have a right to alienate their firearms, meaning they can't possess the firearms, but they can sell them. The law says that the court can order them to go to the police or an FFL. And how do people get those back? They can't alienate their property anymore. So this has now a Fifth Amendment issue in it as well, because people can't sell their property to, I don't know, pay for an attorney to go fight this stuff. Clear takings. You have other issues, 14th Amendment, even potentially 8th Amendment. I haven't even gotten to the Second Amendment stuff, folks. And again, this isn't about just gun owners. This can and absolutely has been applied to non-gun owners. It can affect any person in the state. And so what I would say is, to the proponents of the existing law, will you save this, save the law from itself, or will you allow it to collapse under its own weight? As these examples, horrible examples that you will continue hearing about by others, because I only have so much time, will you save the law from itself, or will you allow it to collapse under its own weight? Introduce legislation admitting you made a mistake and fixing some of these clear and obvious problems that we are showing today. Madam Chair, thank you for your time. I'm happy to answer any questions.
Rep. Breen.
Thank you, Madam Chair. I really do appreciate the diligence you've put into this. And honestly, I do believe there are ways to improve the laws that are currently on the books, but not repeal them. But as you are talking about these cases and the standards to be applied, these are civil proceedings. And in order for the ex parte hearing to proceed, though, are you aware, though, that it is clear and convincing evidence that must be presented in order for firearms to be temporarily confiscated for, again, as little as 2 weeks until a formal hearing is held?
Clear and convincing, Madam Representative, thank you for the question. Clear and convincing evidence of what, per se? The standard, again, is
that somebody posed an imminent threat to themselves or others.
That is absolutely not what the law says, and that is not what you specifically put into the law as the former chair of this committee. Again, it is not that somebody poses a threat to themselves. Let me be clear, and this is a wonderful opportunity to bring this up, because I think it's where we have common ground. Be clear, not middle ground where we have to compromise to agree, common ground where we already agree. There are people that pose a serious, imminent threat to themselves or others. We should absolutely deal with them. That's what I started saying.
I'm so happy we found a point of agreement.
I love it. That's why I started saying this is not whether we handle these people, it's how. My point to you today, if you take anything home, it's that we are not dealing with those people under the law. Because the standard is so low, I'll read it again. Preponderance of the evidence, and
clear and convincing for the ex parte hearing.
And that's exactly the correction I was going to make. Thank you. Preponderance of the evidence for normal, clear and convincing for ex parte, that the respondent can reasonably be expected.
And so the preponderance of the evidence, though, that is when both parties are in court. And by the way, more than 80% of the time, these are being brought by law enforcement and not by a domestic partner or somebody else. And there is about a 20% rejection rate. So I want to make sure that at least we're on the same page when it comes to when it's clear and convincing, preponderance, ex parte, and a full hearing.
I don't think we're on the same page, Madam Representative, because you asked me about an ex parte hearing, but then you said both parties are there. If it's ex parte, by definition, both parties are not there.
If it's ex parte, the standard is clear and convincing.
Correct. But it's clear and convincing of what? It's not clear and convincing that this person will do something, not clear and convincing that this person is a threat. It's clear and convincing that they might do something in the future. That's the problem here. You have this, again, might, maybe standard. Evidentiary standards, we can think about them as a percentage. Call beyond a reasonable doubt, at least 95% certainty that it's true. Call clear and convincing, at least 75% certainty that these are true. Call preponderance of the evidence, at least 51%. I know that's just making it easy, but that's what we're going to do here because this is quick. You apply that to something that, whether it is or not true, is it 51% likely that you did this, that this is true, that you will do this thing? That's not what's going on here. It's 51% likely that you 25% might do something.
Have you attended any of these hearings where this is happening?
I'm sorry, I didn't hear your question.
Have you attended any of the hearings where this is happening?
I have not attended these hearings because they're typically at least a 90% basis happening ex parte.
Have you reviewed any of the case files?
Absolutely.
I'm happy to hear that.
Then
wouldn't you agree, though, that with these ex parte hearings, there is certainly clear and convincing evidence that is presented that somebody poses an imminent threat to themselves or others?
No way, no how, in so many cases. And we didn't even get to the whole bit that I mentioned before of when you present evidence, an officer presents evidence, oftentimes, many times, frequently, they're not even presenting evidence that they have personal knowledge of. When somebody typically has to do something in court, they have to certify something that they have personal knowledge of. It can't be hearsay stuff. Should be if I know you, forgive me for just working with this, and I petition for an order against you, I'm going to have to certify that for reasons that I have personal knowledge of. When officers do these things, they oftentimes do not do so based on their own personal knowledge. An officer will respond, another officer will move for, or will petition for an order. And again, these are vast majority of the times granted on an ex parte basis. Forget the whole hearing part. That is one issue. But when they're being issued on an ex parte basis to this very low standard, which if you take one thing from this law that will make it collapse on itself, it is that low standard that came from this committee. Again, even beyond that, it's the lack of personal knowledge of the officer asserting to it. You then have other things where these officers are oftentimes leaving out absolutely critical information. My friend, Mr. Greenblatt, will be giving you an atrocious case that gives you everything you're looking for to show exactly how this law is being used illegally against people, where they didn't even do something. Somebody else did something. They put the guy in jail. And after putting the guy in jail, they went and got ERPOs against the grandparents that called the police for help against the guy they put in jail. Come on.
I'm afraid we're going to have to disagree on what the evidence is presented and the standard of it.
We are going to go ahead and, Tom, we are going to call up with your, because you guys were kind of all scheduled together. Dean, yeah, he's not leaving the bench, or the table. Yeah. Sorry. But if we can have Dean Greenblatt come up. He was on the scheduled list. Sorry, I missed that earlier when I announced him. And also Casey Armitage, because you guys are all from the same group. So if you want to come up, Casey, as well, supporting the bill, that would be great. And then Rep. Wozniak has a question.
Yeah,
real
thank
quick.
you, Tom, for your testimony. Is there a certain level that a threat has to reach to provide probable cause for the officials to respond?
Which officials? The police or the courts or?
The police, the initial threat.
Well, for the police to initially respond, no. They can just be called out and they would respond to a call. If they're going to do things from there, they must have reasonable suspicion to do certain things or even probable cause at that time to do certain things. Like if they want to get into the house, they would have to have probable cause that there's evidence to get into the house, especially without a warrant, probable cause plus exigent circumstances. So again, when the police have to normally do things, they have to have certain levels. with these orders, especially that low, that maybe standard I keep telling you about, it's lower than the normal constitutional standards for all of these other rights.
So the standard to harm oneself or harm another, does it elevate when the words say gun or shoot are used?
Let me answer this question like this, Your Honor.
Thank you.
Representative.
You're out of order.
I'm used to being in court and train myself that way. Put yourself in the shoes of these judges. Do you want to be that judge that didn't order something and had something happen?
No.
Do we see why so many of these are being issued, especially with a very, very low standard, over 90% on an ex parte basis?
I guess my question's on the other end. Does the word gun or shoot or anything that's like that elevate that probable cause?
It shouldn't, but it absolutely does, typically with a standard person. Because when you say, well, I'm going to go run somebody over versus I'm going to go shoot somebody, society is trained that the latter is going to be treated much differently.
That's what I thought. Because I've heard of incidents where people will call and they'll state that I'm being threatened, and the officials respond saying, well, they're only words, and they won't respond. So that's the lower level, reasonable probability. Thank you.
All right, Dean, you have the floor. Thank you.
Thank you, Madam Chair, members of the committee, for this opportunity to support Representative Sana's bills 41, 38, 39, and 40. I sincerely appreciate the ability to discuss Michigan's Extreme Risk Protection Order Act because so many others, along with me, were denied that opportunity to address it 2 years ago during the hearings in 2023. I am an attorney. I do practice in the area of constitutional rights, and I have substantial experience representing clients in mental health hearings earlier in my career, hundreds and hundreds of those who petitions for involuntary hospitalization were filed. And I was a court-appointed attorney on those because in mental health hearings, the state is required, or the county, and it's a civil hearing as well, are required to provide counsel, something that is denied those who are subject to red flag orders. I do want to share the story of two clients who have been recently victimized by this misguided law. My clients are grandparents in their 80s and 90s who have a troubled 35-year-old grandson. My clients have no criminal history, they have no issues with mental health, and in fact, grandma owns no firearms. The same cannot be said for the grandson, however. He was involuntarily hospitalized 4 years ago for mental health issues and would be homeless after being released from jail after a conviction for a felony if it were not for the compassion of the grandparents. A grandfather owns several hunting rifles, but to prepare for his grandson's arrival, he placed all the firearms and all ammunition in gun safes, and those safes were stored behind a locked door in the home. Grandson simply had no access. Thereafter, the grandson moves into the home in March of this year. Because of the mental health issues and other issues, the relationship between the grandson and the grandparents was troublesome, and the grandparents eventually sought the grandson's eviction, a PPO, and finally filed a petition for involuntary hospitalization with the Wayne County Probate Court. That court issued an order to transport and examine the grandson on October of 23rd of this year, just a couple months ago. The local PD stopped by the grandparents' home but didn't seize the grandson. He refused to go, they let it go at that, and they left him in the home. After that period of time, the grandparents were locking themselves in their own bedroom at night because they feared for their lives. The grandson cut off his tether that was ordered by the county, and the sheriff received notice that the tether was cut and attempted to reach the grandparents, but they didn't answer the call, so a welfare check was ordered. On October 29th, the local PD arrived at the grandparents' home Grandma let them in, they were okay, and led them to the basement where the grandson was. But he had barricaded himself in the basement, and when the officers attempted to reach him, he fired a shot in their direction. The grandparents were removed from the home, and the SWAT team began an 11-hour standoff with the grandson. Eventually, he surrendered. All of the safes were emptied by the police of Grandpa's firearms. But that wasn't enough. The local PD filed for an ex parte ERPO against Grandpa and Grandma, claiming that they were a threat if they were able to purchase a firearm, even though the grandson was charged with 4 felonies and has, and still has, a $755,000 bond requirement. No one's posting his bond, he's not getting out, and he still has the petition for involuntary hospitalization that will need to be addressed. But somehow, the grandparents that have been determined by the court to be a threat in an ex parte hearing, even though they never threatened anyone. They have no criminal history. They have no mental health issues. Now the grandparents are forced to spend thousands of dollars. They're not provided an attorney under the law in an effort to seek to have their fundamental rights restored. This case illustrates something that is quite commonplace, and you'll hear more stories, and I have limited time. But this is fairly commonplace. This is what's going on with this current ERPO law, and I ask the committee to fix it. Do everything you can to fix it. I'd be happy to answer any questions, certainly about mental health hearings.
Thank you. Casey, would you like to speak?
Thank you, Madam Chair and members of the committee, for this opportunity to testify in support of repealing Michigan's red flag laws through House Bills 4138, 39, and 40. I am Casey Armitage, President of Michigan Open Carry, a mother of 3 young adult children and the wife of a combat veteran. So far, I've dedicated 10 years to advocating for our Second Amendment rights. Today, I'd like to highlight the flaws in our Extreme Risk Protection Orders, or ERPOs, by drawing a parallel to something that we all rely on, driving. Both firearms and vehicles are tools that, if misused, can cause harm to ourselves or others. But driving is a privilege regulated by the state, while owning firearms is a constitutionally protected right under the Second Amendment. If anything, we should expect more safeguards for gun owners, not fewer. Yet Michigan's ERPO laws offer less due process than our system for addressing unsafe drivers. Consider how Michigan handles concerns about dangerous driving. Anyone can submit Form OC-88, a request for driver evaluation, to the Secretary of State to report a potentially unsafe driver due to medical conditions, accidents, or observed impairments. This form initiates a review process where the driver is notified and scheduled for a re-examination, which could potentially include vision tests, written exams, or road skill evaluations, before any action is taken against their license. Importantly, the state also doesn't seize the vehicle itself. It only addresses the licensed privilege to operate on public roads, and only after giving the driver a fair chance to demonstrate their fitness. Now, imagine if we flip that script for drivers, mirroring our ERPO laws. Suppose we created extreme risk driving orders, where an accuser, say an ex-spouse or a disgruntled neighbor, could petition a court to immediately tow all vehicles from your household and suspend everyone's driving privileges based solely on their claim that one person, even another driver in the home or a minor who isn't licensed, might be a risk someday. No accident, no ticket, no prior notice, just an ex parte order granted in secret. Police arrive at your home, impounding every car, truck, or van for up to a year, leaving your entire family stranded, unable to provide your own transportation, having to rely on the untimely transportation services provided in your area. Only after the damage is done do you get a hearing, where the burden's on you to prove no one is dangerous. We'd call that an outrage, a blatant violation of due process, opening the door to malicious misuse by anyone with a vendetta. Criminals would just steal cars or drive unregistered ones anyway, while law-abiding families suffer. Yet that's exactly what ERPOs do for firearms. Secret seizures without due process, flipping innocent until proven guilty on its head, and potentially affecting entire households by removing all guns from the home, regardless of who owns them. Just like the hypothetical driving order seizes every vehicle and impacts all family members' mobility. ERPOs can strip away a household's means of self-defense based on an accusation against one person, leaving everyone vulnerable, preventing mom and dad from providing their own protection and forcing them to rely on the safety services provided in their area, with police response times averaging 10 minutes or more when seconds count. This overreach not only erodes individual rights, but punishes innocent family members, transforming a law intended for safety into one that creates division and hardship, all without the upfront safeguards we demand, even for a mere privilege like driving. If we afford more protections to a privilege like driving, including mandatory re-examinations before action, why are we stripping away due process for our constitutional right to bear arms? These red flag laws don't enhance safety. They undermine trust, invite misuse, and fail to tackle root causes like mental health. As a mom protecting her family and a veteran's wife honoring my husband's service to protect our God-given rights, I urge you, pass these bills to repeal these flawed laws and uphold our constitutional protections. Thank you.
Thank you. Rep. Harris.
Thank you, Madam Chair. And this is probably geared more towards the two attorneys that are on the bench. So, ERPOs, are these public record? Once they're filed, are they public record?
Both the orders and I believe the petitions are.
Even if the judge decides that they're not going to take action on it?
Is my understanding the answer is yes.
Okay. So I think there was a comment made earlier about, going another route and that if potentially affecting somebody's reputation. Do you think these could be a reputational issue? They get filed?
Absolutely, yes.
Okay. Thank you.
Thank you. We are going to move on to Zoom here. We have Deputy Chief Hughley. Are you on Zoom still? Okay. Yep, we got you. So I have a card here that you wish to speak in opposition of the bills. Sir, you have the floor.
Good morning, everyone. Good morning, Madam Chair and Honorable Committee. Thank you for the opportunity to speak on behalf of the Southfield Police Department. I've been listening to everyone speak, and I agree it's a larger issue. We definitely, the state of Michigan and the country, for that matter, is in a mental health crisis. And so the ERPO law, the passing of the ERPO law has been an effective tool for law enforcement agencies such as Southfield Police Department to effectively remove firearms in those situations where we believe, based on circumstance, call history, witnesses, admissions, to remove those firearms from that home for the protection of that person that has ownership of those firearms, other residents of that home, and also responding law enforcement. Since the passage of the law, the Southfield Police Department has had 10 incidents, 4 in 2024 and 6 in 2025, related to the filing of ERPOs, related to the removal of firearms. So again, in our opinion, it's an effective measure or mechanism to remove these firearms when we feel it's a situation that's creating danger for the individuals associated with that home. One incident or circumstance that I would like to present here in 2025, we had an individual. We had the spouse of an individual call law enforcement because he was threatening to commit suicide with a loaded firearm. And ultimately enough, he had suffered some personal related issues in the last couple of weeks relating to losing his job, and also some familiar related issues as well. So the culmination of those things had taken him to that point. There were several kids at that home at the time. The incident took place outside in the backyard of the property where the kids were present, some other adults, including the spouse that called us. Once we responded, we found the individual in a wooded type area with the firearm and the magazine being displaced from one another. The displacement of the magazine came from the spouse ultimately tackling the person and them having a bit of a physical engagement to get that firearm away from him. He then left and went into the home and to obtain another firearm, continuing to suggest that he was going to end his life. And so we were able to respond, separate, and we went through that process of committing the person for a psychological evaluation, mental health evaluation. He made admissions to us, and so that was a circumstance where we utilized the implementation of the law to be able to not only safely but legally remove those firearms from the home, again to protect that person moving forward and also protect the occupants of the home. So again, from the stance of the Southfield Police Department, and again, I'm not going to represent law enforcement as a whole. I can just tell you of our experience with it since the passage. It's been an effective tool, and we're in support of the maintenance of the law.
Rep. Harris.
Thank you, Madam Chair. Thank you, sir, for being here. We appreciate your service. I've had some dear friends that have worked for you and in an amazing department. And, there's three of us that sit on this committee that are retired law enforcement. And so we know that you've been put in a lot of positions where maybe you see this as a very valuable tool. And I think we probably have all seen numerous cases where we want to make sure that we can effectively protect the public. So, again, I applaud you for that. My question is, so I've heard from a deputy chief in another Southeast Michigan department where the courts have mandated that their officers that are filing ERPOs have to include their home address. Have you had any of that experience in your area?
You have access to that. So I, not personally for myself, and I haven't heard that contention mentioned. That's something that we can look into. Again, those forms are obviously generated outside of the police department, so that may be a requirement, but I can't confirm or deny it in front here and now.
Okay, I appreciate you, sir. Thank you.
Okay.
I may be able to get that answer for you shortly, though.
I would appreciate that.
Okay, great. Thanks. Well, next up, we're going to have Kelly Dillaha from End Gun Violence, Michigan. You have a couple minutes if you would just approach, in opposition of the bills, wishing to speak.
Thank you, Chair, and members of the committee for the opportunity to speak today. My name is Kelly Dillaha. I am the State Program Director of Red, Wine, and Blue, which is an organization with nearly 43,000 members in Michigan. And I also am a board member of End Gun Violence Michigan, a coalition representing almost 60 organizations in our state, including gun owners. We advocated for the passage of extreme risk protection orders, or ERPOs, 2 years ago, and we're here again today because this law is working and lives depend on it. This law has been used nearly 300 times to remove guns from dangerous situations in the first year, and there have been 0 people charged in that time with abusing the process. But for me, the reason I'm here is that the fight against gun violence and domestic violence is personal. When I was 9 years old, my father threatened my mother with a gun in front of me. He was drunk, he broke into the home, furniture was overturned, and my mother's face was bloodied. Frozen with fear, as a 9-year-old, I'm the one who had to call 911. And the police arrived and saved my mom and my life. And my father didn't pull the trigger that day, so I guess I was lucky. But I often wonder if there had been something like an ERPO that existed then, could my family have been spared that life-altering night? Today, families in Michigan do have access to ERPOs and the chance to get help before a crisis turns into a tragedy. Law enforcement is using the tool responsibly and effectively, as we just heard, and we are all safer because of it. Let me share a few examples from around the state this year. In Battle Creek, a woman's husband became abusive and unstable and threatened to murder-suicide and tried to drag her into a basement where he stored firearms. And ERPO was able to help that tragedy from progressing further than that. In Fowlerville, an intoxicated man paced his yard with a handgun, threatening violence. He was hospitalized, but his behavior escalated further, and he threatened police, hospital staff, and neighbors. The Livingston County Sheriff, who once opposed this law, filed an ERPO to protect his community. In Detroit, ERPOs were used to temporarily remove firearms from the homes of 4 police officers due to domestic violence concerns. And in Flint Township, a man barricaded himself in his basement, fired a gun, and threatened to kill himself. Police removed 12 rifles from the scene. In every one of these cases, help came before tragedy. ERPOs protected Michigan families, and that would mean families like mine. ERPOs are working. As I mentioned earlier, I am constantly interacting with the public through my work, both online and in person. And just want to point out that after a week of horrific gun violence here in Michigan, across our country, and indeed across the globe, House Bills 4138, 4139, and 4140 feel deeply out of step with what people are actually saying in the state. They want safety, they want prevention, and they want lives saved, not regrets after the fact. And that's why I urge you to oppose these bills. Thank you for your time and consideration.
Thank you. And unfortunately, we have one more time for one more. Unfortunately, we have time for one more. It's not unfortunate, the person. So please don't mince my words. Wishing to speak in support of bills, Steve Doolin from Michigan Coalition for Responsible Gun Owners. Steve, you literally only have a couple of minutes as we have another committee hearing here at
No
noon.
problem.
Thank you, sir.
Thank you, Madam Chair. Thank you, members of the committee. Thank you, Representative Sana, for inviting me here. I am an attorney and an adjunct professor of law. I teach a class called Gun Control Seminar for the last 20 years. So we've been debating red flag laws for a long, long time before this ever came up as a bill in Michigan. I'm on the record in public debates as opposing red flag laws for a variety of reasons that you've already heard. But I want to tell you about a specific case I had, which was an ERPO case last year. I had me looking around for Franz Kafka. Here's the situation. 19-year-old Marine reservist attending a program at Michigan State University to try to recruit service members and veterans into college. It's a residential program, so he's living in the dorms. He comes from a state that has constitutional carry, and being a Marine and being very aware of his rights to bear arms, he brought a couple of guns with him. So he's got him in his car as he's going through the program. Second or third day of the program, he has kind of a bad day because he finds out it's going to be a lot more difficult for him personally to get into college than he thought. So you might be aware, suicide is a huge issue with the military. So from the time he joined and went through training, he was trained on suicide prevention. So he was told over and over again during his training that if you feel depressed, talk to someone, right? So he did. All the members of the administration of this program, except for the director, were also veterans. So he went to his RA and said, hey, man, I'm having a bad day, basically. And part of the procedure that he was taught as a Marine is if you start thinking you might do something stupid, get somebody to help you prevent that. Now, in his case, doing something stupid was getting in his car and going to try to find alcohol. So he gives his car keys to his RA. And he says, hey, take my car keys for tonight, will you? Okay, cool. Then he also followed his military training, and he was now handing off a couple of weapons, right? Because he's got 2 guns in the car, because he comes from Georgia where there's no licensing whatsoever, and he's perfectly lawful back home with those guns. So he alerts the person he handed the keys to, there's a couple of guns in the car. So thanks, man, no problem. So he goes about his business. This is about 9 o'clock p.m. apparently what was happening is the leadership of this program were having conversations, including with the director, who finally took it upon herself at 1:50 a.m. to call Michigan State University Police Department and report that they had somebody with a mental health issue. My client didn't think it was a mental health issue at all, and ultimately, by the way, no one did. So about 3 o'clock a.m., the police wake him from a sound sleep, subject him to an extended, non-Mirandized custodial interrogation. But it turns out I don't get to raise that issue because this is civil, right? Even though the police and the prosecutors are involved exactly like a criminal case, and that's part of the Kafkaesque nature of this. So they take him down to the hospital and give him a mental health evaluation. He gets his mental health evaluation, and he's released from the hospital by about 8 a.m. Cleared, not a danger to himself or others. You're good, man, right? So in the meantime, what happened is the MSU Police Department called the hospital, asked for permission to check on what was going on, asked for a HIPAA waiver, essentially. My client gives a HIPAA waiver. Sure, tell him I'm good, right? So the MSU Police Department's now been alerted that my client has cleared his mental health evaluation. So he goes almost directly to the MSU Police Department, asks for his guns back, because he's really disgusted with the whole thing. Now he just wants to go home to Georgia. Well, the desk person says, I don't know, we don't want to give you your guns back, so you got to wait. So they didn't give him his guns back. So about 2 p.m. that afternoon, a member of the MSU Police Department who'd never met my client, never been on the scene, swears out an ERPO affidavit, which is immediately granted. So when we talk about it, most of these are granted, yeah, the process is loose, right? And so we're based on hearsay, actually, that application for an ERPO, because the sergeant who signed it had no personal knowledge whatsoever, and she's reading police reports that it turns out we got a hold of later were wildly exaggerated. At no time, and we've got body cam video and audio, at no time during that interrogation did my client ever indicate that he was thinking of hurting himself or anyone else. What he did say under a lot of questioning at 3 a.m. by 2 armed police officers crowding up against him in the hallway is they said, have you ever thought about suicide? And he was dead honest. He said, well, yeah, hasn't everybody? Kind of something like that. So that was enough. And of course, he thinks about suicide. He's been through all this military training on suicide, right? He's not going to lie. So that was enough for this red flag order to be issued, this ex parte order to be issued. So now he's got to come back to Michigan. He's got to hire an attorney because it's civil. He doesn't have a right to counsel, right? So his family gets together some money to hire me. I'm not a cheap service. And I start looking into it. I get a hold of the prosecutor and show the prosecutor that the MSU Police Department knew that he had been cleared by mental health before they ever signed the order. She says, well, that's some BS. I'll agree to dismiss it, right? So now we go to court. I'm standing next to the prosecutor, and we try to do on the record a stipulation to dismiss. But the judge, who's a well-meaning judge with a great reputation, says, well, these are kind of confusing. We're going to have to figure this process out together because she's got a bench book about an inch thick from Supreme Court Administrative Office. It's only the third one in the county, by the way, at that point. So she says, I don't think I can dismiss it. This isn't criminal. This is civil. I think I have to have your client come back for another hearing.
Sir, I'm sorry to interrupt you, but you literally have like 1 minute. If
All
you
right,
can
I'll
wrap
wrap
up,
it.
we have to, adjourn.
Ultimately, we got my client's guns back, but he had to come back for 2 hearings from out of state and pay me and pay for all that travel in order to get his guns back for something that never should have happened, right? And now he's subjected to an investigation by his chain of command in the Marines because he has a potential mental health problem. Happy ending. Now, a year and a half later, he's doing well. He's been brought on full-time in the Marines, and he's a full-time active duty Marine now. But he went through hell, essentially, because of this law and how loose the procedures are. Thank you.
Thank you, sir. And thank you to everybody that came today and participated. Like I said, we have numerous cards and emails that will go on the record. The clerk will record them on the record. I'm sorry we couldn't get to you today. Seeing no further business before the committee, we will adjourn.